Greetings, my name is Chantell and I'm thrilled to provide you this case study about the antitrust court case, the United States versus Apple. While some of the terms I may say may be a little unfamiliar to you, hold on because a little clarity is coming. So let's get into this case. First, you need a little background to give you an understanding about how this case came about. Apple decided to enter into the e-reader world with its new product release in 2009 of the iPad. Apple also saw the opportunity to sell ebooks through the virtual marketplace on the iPad, known as the iBook Store. Primed with this new money-making opportunity, Apple went to the 6 largest publishing companies to make an exclusive agreement, giving them the authority to set prices, specifically higher price points for new releases and bestsellers. Only 5 of the 6 publishers approached by Apple accepted this agreement. Now, if you're thinking that doesn't sound like it's fair for the consumer, you are correct. The district court set an injunction basically stopping this agreement that restricted their ability to set, alter, or reduce prices and requires Apple to have the same terms and conditions to ebooks as others. At the district court level, Apple and the 5 publishers were charged with conspiring to raise the prices on ebooks that created a unreasonably restrained trade violation for the consumer, which is in violation of the Sherman Antitrust Act. Of course, Apple appealed the decision, but when the appeal reached the Supreme Court, the judges agreed with the decision that was made and affirmed the judgment of the district court. So you may be asking, what is the Sherman Antitrust Act? It is a 1890 law that bans monopolies and prohibits the restraint of trade and has been the foundation of this country's antitrust policy. Apple violated Section 1 by price fixing, which means they were creating an opportunity to allow for prices to be fixed at a certain rate. Section 1 of the Sherman Act bans restraints on trade affected by contract, combination, or conspiracy. The Supreme Court agreed with the judgment of the district court and indicated that there were 2 errors in the Apple's dissent or argument. The first error was that Apple organized this price fixing among the publishers, but it felt it could escape the applications of this law. And the second error was that Apple felt it was entitled to enter into the ebook retail market on its own terms, even if the terms meant price fixing agreements with publishers. With these errors, the court agreed with the decision that was made and affirmed the judgment of the district court.